Welcome to Sweet Spot Safari. We're your hosts. I'm Ben, and this is John. And this week's explorer and guest is John Goodrich. Welcome, John. And John's just recently retired from 22 years as an employment judge and also a tribunal mediator. So yeah, welcome for this next episode and conversation around sweet spots, John. Maybe if we start, how did you get here? What was your career highlights? Having recently retired and probably reflected a little bit on them.
Thank you. Yes. Well, perhaps firstly, I should say that I'm giving my personal views as a recently retired employment judge. I'm not attempting to represent the judiciary or the employment tribunal service or anything of that sort. So just a little bit about my background. I was a solicitor in private practice. There's a lot of judges, of course, that are barristers and perhaps have the advantage that often they're more used to being day in, day out in court. My background was a solicitor. I worked in the voluntary sector, in private practice, and in local government. So I had quite a broad background as a solicitor, and partly some of the time I did have employment law as a specialism. So I had a reasonably varied background, which I think in terms of employment disputes can be quite useful.
Oh, great. Yeah, thank you. Oh, sorry, I was like cutting you off halfway.
No, you were asking, I've forgotten that you were asking about highlights.
Yeah.
I think one thing to say about employment tribunals is that our work is enormously important in our lives. And so whenever I did a case, I was quite conscious that firstly, it might be the only time that the particular individual would be in an employment tribunal, particularly if they're either an employee who maybe would never have taken another case in their lives, or maybe a small employer. So I was conscious of that. And also, I could never accuse any of my people in front of me of being uninterested in the result. So there was always, particularly if someone was unused to tribunal service, there was a tension, and I would try as a judge not to make people more tense than they were already. And of course, every judge has slightly different style. And it felt for a lot of people as though there was a lot at stake, even if the amounts they were claiming were quite small. So at one end of the spectrum, there might be someone who said worked in catering for a few months and left having not been paid all their wages, they said in their claim, or claiming maybe a few days unpaid holiday pay or something like that. So that might be one end of the spectrum of a case that maybe be listed for 1 hour, 2 hours. And on the other end of the spectrum, there could be cases with years of allegations and difficulties in the relationships and multi-witnesses, thousands of pages of documents, and a long hearing. So it was a very varied role to have, and particularly where I was working in London, there would be a mixture of high-earning employees, and on the other hand, employees who maybe were somewhere around or near the minimum wage. So it was a big variety of work, and every case tended to be a little bit different.
Yeah, thanks. I think you've given me a picture of the courtroom, and it's pretty obvious when you think about it. It's an interesting vantage point, an arena to view, society and different patterns which are happening throughout society. And I think you quite clearly you articulated the challenge of inequality there. Perhaps that actually you kind of get all really two ends of the scale, quite often in front of you. So it seems like a good vantage point and window into how our society functions. But I wonder if actually it's a useful place to start we all seem to be swimming in laws and rules and whatnot. But what is the legal system? What is law? What's its kind of what is its purpose? Just if we start with the basics, would you say?
Yes. Okay. Well, to take employment law, it's had quite a long journey. Even at the beginning of my career as a lawyer back in the mid to late 1970s, employment law tended to be called the law of master and servant. And that tells you something about the approach. And what happened, particularly in the more unionized industries, was that because there weren't such rights as the right to be not to be unfairly dismissed, there were quite a lot of strikes. If, say, someone within the workforce got dismissed and work colleagues weren't happy about that, people would go on strike. So the original intention of what were then called industrial tribunals back in the early 1970s was to have an alternative to this sort of strike action. So it was moving from collective action to individual rights. So it created a right not to be unfairly dismissed. And the intention at the beginning was that they should be very informal setup. So quite often they might be held in some function room of a hotel, or maybe a room in a local authority or something like that. Trade union representatives might appear, but there wasn't an expectation that people be represented. There was an expectation that there would be justice delivered swiftly. And with unfair dismissal, the original intention was to have the right, if someone was unfairly dismissed, a tribunal would have the power to order re-engagement or reinstatement, put them back in. In practice, in my experience, that very seldom happened. So even on the very few occasions where someone who'd been dismissed was asking for their job back, the employer would generally say, no, I don't want them back. So it was extraordinarily rare in any of the unfair dismissal cases I had for that original objective to be maintained, for the person who had been unfairly dismissed to get their job back. So generally, the hearings that I had, the trials that I had, were geared at compensation if the case was successful. Another important thing to bear in mind with employment tribunals, as they're now called, rather than industrial tribunals, is that in most civil litigation, the loser pays the winner's costs. So that's a principle that's key, say, in the High Court or County Court civil litigation. In the employment tribunal, each side generally pays their own costs. There is provision if someone behaved unreasonably in the litigation, and in a few other limited circumstances, to order that one side pay the other side costs. But it's a rarity. And as time has moved on, the employment law has become much more complex, because particularly as European legislation came in, there were a lot of new types of claim, but also employment tribunals started in the early 70s, and in around 1976, 77, the Equal Pay Act came into force, sex discrimination law, race discrimination law, then later on, influenced by Europe, what's called TUPE, Transfer of Undertaking Employment Regulations, which allow, when there's a change of employment, business changing hands, generally that will give some protection for the terms and conditions of the people who are working when the business is taken over. So it's become much more complex. There's very few trade union representatives that attend tribunals now, partly because it's more complex, partly perhaps a question of resources. So it's a very different type of jurisdiction to when it first started. And there's tribunal rooms that are quite formal, a bit like ordinary courtrooms. There's witness statements, cross-examination, closing submissions, detailed analysis of the law. I've had cases where I've had closing submissions over 100 pages long with 40 odd cases being cited. So it's a long way from the original intention.
Mm. John, do you want to come in on any questions that you have?
Well, yeah, just briefly, it was a very interesting observation that I picked up from both of you, and then I want to talk a bit about jurisdiction, which I think would be quite interesting in the global world. Is first of all, I know, Ben, when you alluded to the fact that when John was originally talking about, very high net worth individuals and highly paid people in the city down to people who are on minimum wage, there was a level of inequality. But I think my feeling is that in terms, and alluding to the point you made at the start, both of high value to the individuals, because we live in a relative world. So it doesn't really matter if you're a high net worth individual or a highly paid individual, or whether you're a thing. At the end of the day, it's what matters to you at that point in time, which is, the power, I think, the importance of having justice and a tribunal. But it was interesting you were saying about particularly jurisdiction in the EU. I've come across more company law more recently in my career, and having to deal with different jurisdictions and global, global companies and people fighting in terms of, if you're going to have an NDA, where do you want the jurisdiction to apply? Have you found that with the globalization of companies that there's another layer of complexity around jurisdictions? When you've got maybe somebody in head office wanting to, set an example, in terms of an employment law, and it's in a different jurisdiction. Does that create any particular stresses, or do you tend to find that it's all contained within one area? Usually it's between managers and employees in a particular jurisdiction.
I think globalization can add more complexity. There's partly a question of perhaps culture, that say a multinational American company might have different values, say, to a British company. There's also, with multinational working, there's quite complex law as to whether a British employment tribunal has, or I should say England and Wales was my particular jurisdiction, has the power to deal with a case for someone who's, say, working primarily in the Middle East or Far East or America or wherever. So there's that area. There's also questions of service of proceedings and the permissions that are needed in order to serve overseas or to have a witness give evidence from overseas. And also there's sometimes a tribunal may have a witness who's actually abroad at the time of the hearing and giving their evidence on a screen in front of the tribunal room. So there's a number of different dimensions, certainly from the global economy and the multinationalization of quite a lot of the employment.
Mm-hmm. Just on the complexity issues, I don't know if you've got a follow-up question to that, John, or
no, please go ahead. Mine was one on complexity as well, but you may answer. You asked the same question, so go ahead.
Well, maybe, but I'm just wondering whether, and I just quite anecdotal. I'm guessing the legal industry's got larger in recent decades. Is that kind of in part a reflection of the increased complexity and the growing legal frameworks, or is it also perhaps a reflection of our culture and the inability to find compromise and agreement, and actually sending almost having this kind of confrontation by default, rather than trying to work things through? Actually, we'll just pass it to the lawyers. I don't know if there's both things in play. I'd probably naturally the first one.
It's a bit difficult to say. I haven't got statistics to hand on how the legal profession has developed. Certainly, it's my impression that it's been a larger profession than it was. And as you might guess from what I was saying about the origins of the law of master and service, master and servant, and then having the concept of employment law protection, that certainly taken employment law from something that back in the early 70s, there were very few law firms that were involved in it, to decades later, most legal practices would have to have someone with some understanding of employment law, except the perhaps very niche ones. But most medium-sized to large practices, by certainly the late 90s, would have an employment law practice.
I was just wondering on that, Ben, which sort of links to yours, is that at the start of the conversation, John, you mentioned that when employment tribunals originally started, or industrial, and I remember when they were in, and I remember the development of those acts that you recall, is that arguably justice may have been swifter then, because it was in an informal nature, and the intent was very much more to resolve a situation, to avoid either strike action. And it's more a general question, is, do you think this level of modern complexity and the formality of the process, you wondering, and maybe it's a difficult question to answer, is whether we're actually helping the people who need the help? You know what I mean? Is the complexity actually working against those people that need the support? You know, it's more a philosophical question, I think, John, if that makes sense.
No, I think it's a good question. And employment law has become complex. Employment judges are used to people having to act for themselves because of the absence of legal aid. And with fewer people getting legal aid in civil litigation, then judges in the county court have also had to become a bit more used to having people acting for themselves rather than having lawyers. I did also have a spell of doing a bit of work in the county court, and certainly even then, that was probably about 7 or 8 years ago now, even then I found that there were a lot more people who are represented in the county court than in the employment tribunal. And so if someone's representing themselves in an employment law, particularly if they feel, well, I'm a woman, I'm not being fairly treated, I think, because I'm a woman, or maybe this happened because I'm my race or color or something of that sort, and they're needing to bring a case and they don't have money, it's very difficult for that individual to really know whether they've got a good case or not. So I think to that extent, the complexity of some of the employment law doesn't help. Now, I suppose if legal aid were to be expanded to allow at least the more complex employment cases to get legal aid, then that might change. But as a judge, if someone was representing themselves, I would, particularly if it's a multi-day case, I would come into the case maybe having got the papers the night before and would have to read my way through it. And then if the claimant didn't have a clue what to ask, I would be needing to think, well, I've seen what they think their case is. These are the sort of questions I need to ask. And that's quite a difficult job when I'm the judge, not either their person's lawyer. And of course, occasionally, most employers on the whole tended to be represented. Likewise, if there was a small employer, say, who didn't really know much about employment law, I would again be having to dig into what their defense of the claim is and what sort of questions needed to be asked in order for me to get to the bottom of what had actually happened, try to work through any conflicts between the two sides, between the two versions of what had happened, and then apply the relevant law to the facts, again with no help from either party, because they didn't really know what the relevant law was, but one or both would probably have a burning sense of injustice about being needing to be in the employment tribunal at all.
Yeah, it's really interesting, that one. It's because I was thinking of medieval times when you were talking about the worst extreme, you know, when we had trial by ordeal, you know, and the sort of witch-finder general and all these courts where somebody sat, you know, as almost judge, jury, and dare I say executioner and thing. And unfortunately, we've moved a long way from that. But it's a really interesting analogy you say, isn't it? Is that sometimes the development of a system may be self-defeating, right? When it starts to go away from the person that's involved in their knowledge and understanding without specialist help that they can't afford, you know?
Yes. Absolutely, yes. I mean, some people do have legal insurance, and I think some people don't know, perhaps, that their household contents might have insurance for up to a certain amount of legal advice or something, but most people don't. Most employers would have some sort of ability to be represented, whether they'd have some kind of insurance policy with some organisation that provides employment advice, or they'd have an in-house lawyer, depending on the size. A smaller employer, obviously not, and they perhaps feel equally disadvantaged to any employee without representation.
Yeah, and I think you got me thinking, John, about like the medieval arena of judges and you know, deciding who and who doesn't get punished. And I don't know if you've thought about it, John, but I grew up a Catholic. I went to church every week. I went to religious school. But we live in largely a secular time where, you know, religion and you know, faith doesn't play such a significant advantage as it did a few hundred years ago. And I just wondered, it seems like maybe the legal system and, you know, judges and lawyers are almost like a kind of secular replacement for the church in helping us decide what we should and shouldn't do. It's almost kind of codifying kind of maybe kind of principles into actually, you know, into laws. And I don't know if that's massively offbeat, or whether that's something maybe I'm onto something.
I think moral values do come into legislation, don't they? And successive governments tend to have their say on employment law and have a different view on where the balance between employee and employer rights are concerned. But more generally, looking at law, it's where law breaks down, then vendetta tends to come in, doesn't it? And there's plenty of societies, even recently, where that's represented. But going back to, John, what you were saying about Middle Ages, there was times when animals would get tried in court. So let's say a pig had, let's say, savaged a child or something. The pig might be prosecuted and have some representation and be sentenced to death or whatever. So there's an intriguing history. And of course, then the church court used to be very important in this more secular age. The kind of ecclesiastical courts are relatively obscure, but centuries ago they were important.
And so what might we be doing today, which in 250, 300 years time people might look back and think, well, you know, in the way of like trying a pig, which seems ludicrous, you know, are there things which actually on reflection, looking back, maybe we do at the moment, which we'll think quite differently about? Or is it just very difficult because we almost have to have that kind of, you know, rear view mirror perspective?
It's difficult looking at trying to speculate, and I don't claim to have any real crystal ball. But if I look back, let's say 40, 50 years, there were an assumption that a woman that got married once they had a family were going to be out of their job. So the woman was more looked on as being sort of pocket money for the main provider. So it wasn't at all uncommon, both for women to be dismissed simply because they had a child. And often the woman wouldn't have the same pension rights. Mm-hmm. And now that it's much more common for both parties in a marriage to remain in employment even after having children, most people would think that, only in this culture, would think, well, that was very wrong, but it's not long ago that was the case. And indeed, early on in my stint as an employment judge, we were still dealing with claims arising from women who hadn't been allowed any pension rights, whereas the men were given quite generous pensions. So even that shows quite a change in attitude in a relatively short time. So I dare say in 100, let alone 200 years' time, there'll be many things we do. Well, my children probably have quite different values to the ones I was grown up with. So who knows how things will evolve.
It's interesting, isn't it, about perception as well, John? So again, following on from that, if that's okay, is I'm wondering, and I'll cite a little brief anecdote in a minute, but I wonder if there's a case for more education around the law in the general public and at school. And, you know, certainly something I wasn't taught at school. It was very much the 3 R's, you know, and my education. And if there was a greater understanding of the law and legal principles, you know, and culture and how that affects law, that we might have a more easy, balanced society where people not only find understanding things easy and resolve things quicker, but also understand other cultures. I mean, I work quite a bit in the Middle East now, doing a lot of cultural transformation work. I'm about to sort of retire from that in a bit, working on cultures. And there are perceptions we know about cultures, whether it be Russia, as we talked about, or whether it be the Middle East or the West or other places. And I was chatting to a lady we befriended over lunch because we were working the same open space out in Abu Dhabi a year or so ago. And she was a Lebanese lady working for PwC, you know, the big accountancy and management consultancy. And she was very open with me. She said, "Oh, I'm getting divorced," and she was married to a Muslim guy. And it was sort of like, I was surprised. It was just general chit chat. And I thought, okay, that's interesting. And it got to the point where she said, well, actually, I'm getting divorced through Sharia law because actually it's more efficient for me to get, you know, divorced through Sharia. And I'm not judging one legal system against the other, but what I'm saying is there are perceptions around the world, you know, around different legal systems. And I'm just wondering whether generally, if we were, and cultures as well, if we were more educated around the laws, legals, and the principles and values that go with it, we might have a more cohesive society.
Harmonious, maybe, yeah.
Harmonious, thank you. That's a better word. Thank you.
Yes, I agree, firstly, that having some sort of basic understanding of law and why they're there, why the laws are there, what they're seeking to achieve, how they operate in practice, I think all of those are useful. I did at one time have a couple of 15-year-olds doing a week's work experience sitting in on me. And I think that was quite eye-opening for them, as well as interesting for me. So I think there definitely is a role for that. Whether it would make our society more cohesive, a bit more difficult to say, because I think there's a huge number of factors that lead to lack of cohesion. So I would have thought it would be a very small part in a large equation.
Yeah, I think you're probably I think you're probably right. It does make me think that there's quite often in schools, financial education, how to manage your money. But I think it's a really good question actually by John, and it does make me think of trying to think who it was that basically they said that they wish they went to school and school provided 30 101 courses. So basically you kind of learn little bits of everything about how society works and about science. And I'm quite interested. I've had dealings with the legal industry. I worked in the insurance industry for quite a few years, and so a lot of those, some cases obviously inevitably ended up in court. So working with the legal system on your side, and I kind of got a small window into the legal system. And although that was some time ago, it has given me a kind of foundation for understanding just where law, shapes what we do. It shapes our choices. It shapes how we resolve problems. And I think it would be valuable, because I think that law, touches a lot of what we do. But it just makes me think also about the history of industrial tribunals, which you've mentioned earlier in the conversation. And I don't know if you've switched off from reading the news since you've retired, John. I probably wouldn't blame you. But obviously, there seems to be just lots of strikes, and obviously that was happening when you were still sitting as a judge. But I kind of sense that these are a sign that changes are afoot. Maybe not just in employment law. There's obviously the rise of the gig economy, the rise of AI. Coming out of the EU, there seems to be just lots of things kind of going on, and I don't know if you can kind of give us a gist of how things have changed in the last couple of years from an employment law perspective, and what you were seeing. What are some of the changes and patterns, perhaps?
Well, taking the so-called gig economy, that has very much been in play in employment tribunal jurisdictions and aims. So essentially what the economy is geared to is taking away the employment rights, such as the right not to be unfairly dismissed for discrimination, by creating these platforms where they're often with agreements that are drafted by lawyers that are doing their best. I think what one court of appeal just described as armies of lawyers seeking to create agreements that get their client out of giving any employment protection. So that for years has been quite a battleground in the employment tribunal jurisdiction. And of course, there's a political issue as to what extent people should be given any employment rights. And eventually the Supreme Court made various rulings which were trying to look at the reality of the situation. So the relationship was basically one of employer and employee, or what in the old days would be called master and servant, then some degree of employment protection was called for. So at the higher end, if someone is an employee, they have greater rights than someone who's classified as a worker. So it's a similar sort of test. And someone who's a worker has more limited rights. The right, for instance, to holiday pay, for example. And someone who's neither an employee nor a worker, they're outside the kinds of protections that employment law brings. So that's certainly been a battleground for quite a number of years. And I've done many cases where there's been a dispute as to whether someone is an employee or a worker or neither. Then UP's often been an area of dispute, the transfer of undertaking regulations, whether someone who was an employee transferred over to the incoming employer, or were they an employee at all, the incoming company or individuals taking over saying, well, no, they weren't. So that's certainly been one of the fertile areas of dispute over the past few years. And ultimately, it's a question of interpreting the legislation, which side of the boundary line it falls under.
I was just wondering, Ben, building on that, as you were talking, and again, going right to the start of the conversation and the history of employment law from John around, a means of getting early settlement in the cases of strikes, which of course collective. And I remember the days of what they used to call free collective bargaining within the unions, where the trade unions used to bargain. And I look in the current rise of strikes, it doesn't matter which denomination it is, whether it's the doctors, the teachers, or the train drivers, or many other public service employees. What they have is, of course, collectivism. So then when we look at the demographic that you talked about, John, which is workers, for instance, or contractors, they don't really have any collective rights at all. And I'm just wondering whether there's sort of an upsurge in this, and whether it's going to move that way. Because again, without talking about specific cases, I remember there was the one with the Uber drivers, weren't they? They fought that case with their employer, and the employer basically tried to say, well, actually, you're a series of contractors or subcontractors. And they tried to say, well, actually, you determine our working framework. You tell us what the type of car we have to drive, what stickers we have to put on there, for by definition, there's effectively, what they call, is it co-employment or whatever along those lines. And I'm just wondering whether the societal element, Ben, is that there's a need for collectivism, whereas we've been very individualistic, for a number of years, and now that there's a push in that way.
Yes, well, trade union membership has declined, and there's been a big shift over the past decade, hasn't there, to the public sector being privatized and having it run by private companies rather than remaining within local government or water authorities or whatever. So that's certainly been a change. And so there is the balance, depending on which bit of the political spectrum you sit on. There's definitely a view that the whole issue of putting people, taking away people from local authorities and the like into the private sector has led to a greater inequality of wages, with the people at the top paying themselves a great deal more and squeezing down the wages of the people at the lower end of it. So that's certainly a view that advocates of collective action would agree with. And then on the other hand, the people that are in favour of individual autonomy and the rights of employers to dictate things, view things differently. So employment law certainly has quite a political dimension, which goes back to what I said about it depending on particular government. Because I remember when the Transfer of Undertakings Regulations 1981 were enacted, which were brought in by European legislation, the minister, the Conservative minister, saying he brought it in with remarkably little enthusiasm. So it's the question of balance is one that between the conflicting positions, employer, employees, workers, people on the gig economy, is where it's struck is very much something that politicians disagree about. And as a judge, I'm there to try to interpret whatever the government of the day has as the legislation. And whilst obviously I have an opinion on it, as a judge, I'm there to interpret it. And broadly, I felt comfortable with the balance that I've been trying to strike over the 20 odd years. So I haven't ever felt that in general that I was doing something that offended my own values and conscience. And for that reason, in part, it made it a rewarding area of work to be in.
Yeah, that in itself is very interesting, isn't it? Because I think if, you know, somebody who sits like you in that profession, if you feel comfortable around the way things are playing out, you know, against your own values, that sort of implies indirectly that the system is working the way it should do, right? Because if you take it to its purest point, somebody in your role should never feel stressed, right, in that situation. Because there, to me, it's implicit there's a lack of bias, for instance, you know, which is what we want. To me, that's the whole purpose of judge, isn't it? You know what I mean? Is weighing up the evidences on either side, you know, and giving the direction in an unbiased way. So I think that in itself is quite a powerful observation. I did think, as you were saying, when you were talking about the gig economy and employees and the wage separation, as you say, as people have moved into that economy within the public sector, it reminded me, I wonder whether we're in a cycle again, Ben, you know, like the sine wave we've talked about, because it reminds me of barons and the feudal system, you know, where workers got paid minimal wages, you know, were expected to work and they didn't have any collective rights, you know. And again, this isn't a political statement. I'm interested in the system and the process, you know, whereas it was, you know, that regions were run by barons, you know, in a feudal way, you know.
Yes, well, I did do history A level. I did study the feudal system. It's a long time ago.
Yeah, and yeah, we might have some sort of like techno feudalism coming down the pipes, which some people, you know, are talking about. But yeah, I think lots of change afoot. But I think we're kind of rounding off towards the end of the conversation. It's been really insightful. But I think you helped us naturally, you know, pivot towards the end where we start to think about sweet spots. And you talked about the balance there of you know, weighing the different parties, weighing the evidence. And I think ultimately your role is trying to see quite often conflicting opinions and trying to interpret results and try to reach a judgment. And yeah, so I don't know, maybe just, you know, how much of what you do is really trying to find a compromise. Is that a big part of the process of this?
Well, I think firstly, it's worth bearing in mind that most employment tribunal claims that are started don't go to full trial. So there's a lot that are settled through ACAS or people drop by the wayside or whatever. So it's only a minority of cases that actually get to a full hearing. So let's say one or both sides are well represented, then that helps people reach some sort of settlement that they can live with, because it's going to be cheaper realistically to try and settle something outside court than go through some full battle. And particularly if someone is still employed, as let's say bringing a discrimination case whilst remaining an employee, it's not going to do any good to relationships to have people at each other's throats in an employment tribunal. So a lot of cases do settle, and the system is geared to trying to help people settle. Whether it's geared well enough to get back to the question of legal aid and people having competent legal advice to know where the situation is. So I think firstly, a lot of cases do get resolved without trial. And I mentioned mediation, I mentioned ACAS, and people perhaps just running out of steam one way or another, or not wanting to go to court. When a case, if it's a multi-day case, there'll usually be a preliminary hearing to try and sort out what are the issues that are going to trial, make case management orders so the case is ready for trial. And that can sometimes be an opportunity to have a bit of informal discussion about the case without trying to seem to be biased, but it does give an opportunity for a bit of an exploration, and that in turn can help cases settle. Mm-hmm. And then also I might bear in mind that as a judge hearing a case, at least 50% of my client group, the warring parties, are going to be unhappy with the outcome, because it's very much one side wins, one side loses. Occasionally, both parties may be cheesed off with the outcome, but it's not a popularity case, contest, when 50% of my client group are likely to be upset or angry about the outcome. Mm. So it's not necessarily a good job if wanting to be super popular.
That's very interesting.
I mean, all I can try and do is make each side feel that they've had a fair hearing and that they've had the chance to say the things they really needed or wanted to. Yeah. And they've been listened to. And I think that in itself is an important function, particularly at the end of an employment relationship, things can be pretty fraught.
Yeah. And I think just on that fairness point, perhaps I'll just finish off on this this question, and maybe it's just a societal perspective. How well do you think the legal system is balancing those that have power and influence versus those that are disadvantaged? So is the legal system working for all, and how is that tension playing out? And do you think that that's always in the balance? You mentioned things like legal aid, and it kind of, for me, it seems like the legal system is a power for good, but it can also just reinforce perhaps divides already existing.
Yes, I think firstly, particularly because of the absence of legal aid and the complexity of some of employment law, it's tremendously difficult for someone for whom maybe English isn't their first language, or not particularly educated. It's tremendously daunting and difficult for them to bring an employment tribunal claim. I don't think there's much question that having access to good legal representation makes a difference. So in that sense, I think that's one problem with the legal jurisdiction. The other is simply funding, because when fees were introduced to employment tribunals, the budget, I think, was cut. And then when the fees were declared illegal, I'm not sure that the budget ever got restored to its previous level. So the upshot of that during the last few years I was working as a judge was that, particularly in London, we had very long backlogs to getting a case. So the whole point of the original employment jurisdiction was you'd be in court or in the tribunal, or industrial tribunal as it then was, within a matter of a few months, if not weeks. But for multi-day hearings in some parts of London, there could be a 2-year wait to get the case to actual trial. And that is not really a good form of justice. There has been a recent recruitment drive to get more employment judges. And in fact, one of the reasons I stayed on as long as I did was to try and give a bit of a helping hand until a new batch of judges got appointed. And once we got a new batch in, I thought it was quite a good time to go. But certainly, even at the time I was leaving, a multi-day case being listed in this year would be lucky to get it heard next year. So far too long a wait, and that just exacerbates problems. And I don't think it's any different in the county court. My experience in the county court has been long delays as well. So I think they need to be tackled in order for the legal system to be functioning properly.
And so I think it sounds like there was a process sweet spot, but I think the structural or systemic sweet spot is a work in progress by the sounds of it. But yeah, well, thanks very much for sharing your experience with us, John, and all of your words and wisdom and insights into your career. So I think you've illuminated a great deal about the legal process and legal system. So thank you for joining us on Sweet Spot Safari. Yeah, I think we will be back again soon. So check out YouTube. Please follow. And if you'd like to share this conversation with people you know, please do so. And we'll see you again soon. Thanks again, John.
Well, thank you. And if it's of any use or interest to people, I'll be pleased. So thank you very much.
That's kind. Thank you. Take care.
Okay.
Pleasure.